Welcome to the law of contract. I hope you enjoy the class from previous subject, and I hope you also glad to see you everyone here. Now we are discussing about why we need to learn a contract law. Those engaged in commerce are continually entering into agreement, for instance, contract. Essentials to know those agreements. Why? Whether they are regarded by law as valid and enforceable by legal proceedings. Whether they are mere agreements and not enforceable. The law of contract is the basis of your commercial law. It's a commercial law. Governs, for example, sales of goods, agency, negotiable instruments, insurance agency. You work closely with the insurance. There's a partnerships, trade partnership, for example, and many more. Learning outcomes of contract law, we expect that you will understand what a contract is and how contracts are formed. We will also outline the key elements of a contract. We try to explain the difference between an offer. I try to explain the difference between an offer and an invitation to trade. I expect that you become familiar with the contract law and its terminology. By then, you can apply legal principles to given facts and demonstrate criticality and analysis when answering facts-based questions. Further, in analysis case law and be able to apply this case law in a persuasive manner to hypothetical case studies. There's some definition of a contract. First definition by Pollack. Contract is every agreement and promise enforceable at law can be defined as a contract. There's also this definition by Salmon, whereas contract is an agreement that is creating and defining obligation between parties. Then there's a definition that said contract is an agreement that is enforceable by law. In a definition of contract, you will see first an agreement between two or more parties under which legal rights and obligations are created which will be enforced in the courts. The second thing, you can see a promise or a set of promises which the law will enforce. The third one, an agreement that the court will enforce. In the form of contract, you will see a written contract, verbal or oral contract, or you can see partly oral and written contract. Enforceability is it's do happen in an agreement that is enforceable if it's recognized by court. In order to be enforceable by law, the agreement must create legal obligation between the parties. How is actually contract law being developed? The common law once required all contract to be in writing with a seal affixed. Later, some payment was required before a contract could be enforced. Mutual promise became enforceable in the 160s. By the 190s, court began to consider the fairness of contract before enforcing them. Then we discuss about the classification of contract. That is includes simple contract, contract under seal, express and implied contract. Then you will define the contract as bilateral and unilateral contract. You will also define under a contract under valid contract, voidable contract, void contract, and unenforceable contract. We will then discuss each of these terminology one by one. Simple contract is actually all other contracts that are not made under seal. It might be oral, wholly or partly in writing. It must be supported by consideration. What about contracts under seal? A contract under seal or a formal contract is referred to as a deed, must be in writing and signed, sealed, and delivered. It does not require a consideration. There should be attested by at least one witness who is not a party to the deed. Then we discuss about express and implied contract. If the intention of the parties in agreement or contract are stated in explicit terms, either orally or in writing, they constitute an express contract. While an implied contract is one in which the terms of the contract are inferred from the conduct of parties and the surrounding circumstances. What about the classification of contract that cover express and implied contract? Express is actually the two parties explicitly state all important terms of their agreement. Implied is actually the words and conduct indicate that the parties intended an agreement. Executory and executed contract. Executory contract is when one or party has not fulfilled its obligation, while executed is when all parties have fulfilled their obligation. What about bilateral and unilateral contract? Now we come into to explain about these two terminologies. Most contracts consist of the exchange of mutual promises and the actual performance of which is to occur at some future time. Such a contract consisting of promise for a promise, which is actually a bilateral contract. While a unilateral contract is one in which an offer is made inviting acceptance by actual performance rather than by a promise. Bilateral contract. The situation of bilateral contract does happen when a promise by one party in exchange for a promise by another party. For example, a one-to-one contract. An offerer, for example, the person who made the offer, then offeree has to face the offeree, which is the person to whom the contract was made. I'll give you an example. Sale of good contract. The buyer promises to pay the price, and you also see the seller promises to deliver the good through the third party, for example, through GoFood or Gojek or GoSend. Yeah, a unilateral contract does happen when a promise by one party in exchange for an action by another party. One-to-all contract. One offerer give a promise to many offerees. For example, X promises a reward to anyone who will find his lost wallet. Then X bound himself to the promise, but no one is bound to search for the lost wallet. But if Y, having seen the offer, then recover the wallet and returns it, he will be entitled to the reward. Then we can continue with the classification of contract. There's a valid, enforceable, voidable, and void agreements. Valid is when you satisfy the law's requirements, while unenforceable when the party intends to form a valid bargain, but some rule of law prevent enforcement. Voidable is when the law permits one party to terminate the agreement. Void One the neither party can enforce, usually because the purpose is illegal or one of the parties has no legal authorities. Okay, then you will see on page 20 how the chart describe the classification of contract in a more convenient way between bilateral versus unilateral, express versus implied, executory versus executed, between valid versus unenforceable versus voidable and versus void. In bilateral and unilateral contract, in bilateral both parties make a promise, while in unilateral one party makes a promise that the other party can accept only by doing something. We then continue to remind you, I continue to remind you about the sources of contract law. There's a common law, there's a uniform commercial code. In the UCC Article 2 governs the sale of goods. Goods mean anything movable except for money, securities, and certain legal rights. In a mixed contract, Article 2 governs only if the primary purpose was the sale of goods. What is the essential element of a contract? A contract is an agreement that the court will enforce. Essential of a element of a contract is include an offer by one party and its acceptance by the other. The intention of the parties is to create the legal relation. There's a valuable consideration unless the promise is made under seal, for example, by deed. There's a legal capacity of the parties to act. There's also genuine consent by the parties, and there's a legality of the object of the agreement. What is the essential element of contract? First is agreement, which is include offer and acceptance. There's a consideration, which is there has to be bargaining that leads to an exchange between the parties. Then there's a legality, where the contract must be for a lawful purpose. And the last is actually capacity, is when the parties must be adult of sound mind. In agreement, one party make the offer, another party accept it, and the offer and both achieve consensus at item meeting of the minds. In consideration, both parties must have provided consideration. For example, each side must promise to give or do something for the other. The intention to create legal solution is actually the next step. The party must have intended their agreement to have legal consequences. The law will not concern itself with purely domestic or social agreement. What is the capacity? We will discuss the issue of capacity on the next meeting. However, I will give you the brief explanation that in this situation, the parties must be legally capable of entering into a contract. In the absence of vitiating factors, absence of factors that are going to invalidate a contract, for example, duress or undue influence, mistake, misrepresentation, and illegality. We will discuss in more detail in the next meeting. I'm going to explain you the negotiation terms between Joe and Bob. This is a good example and simple way to explain. The situation is Joe giving an offer to Bob, while Bob then accept or reject the offer or counter-offer the offer from Joe. After that, Joe can accept or reject or counter-offer as well. There's an essential element of contract that we discuss and we can summarize, that is include offer, acceptance, intention to create legal relation, consideration, capacity, certainty. Please make sure that you understand the detail of this term and terminology uh, during your self-study or during your spare time. There's a type of agreement. Next, we are going to discuss this one, which is actually social agreement. Social agreement is actually are not enforceable. Why? Because they do not create legal obligation between the parties. For example, you get invitation for dinner. You will come or not. There's no legal obligation unless you have to pay. You have to pay the invitation, and then by agreement you get the dinners. You get access to the dinner. What about legal agreement? That is actually an example. Last example I gave you. Legal agreements are enforceable because they create legal obligation between the parties. Example, A promised to sell his car to B. Enforceability, in this case, an agreement is enforceable if it is recognized by court. In order to be enforceable by law, the agreement must create legal obligation between the parties. Void contract. In the case of enforceability, the whole transaction in void contract is regarded as a nullity, as though as there has been no contract between the parties. Any goods or money obtained under the agreement must be returned. Where items have been resold to a third party, they might be recovered by the original owner. A voidable contract will be operated as a valid contract until one of the parties takes steps to avoid it. Anything obtained under the contract must be returned insofar as this is possible. If good has been resolved before the contract was avoided, the original owner will not be able to reclaim them. In the Contract Act, contract include agreement plus enforceability. Agreement include offer plus acceptance, while enforceability is legal obligation between parties. The illustration of simple express written contract will be reviewed together on page 47. You will see the example of contract. You might think about the parties that are involved. What is the agreement? You can also check the amount of deposit that is included. When is the completion? Somehow you can see the specification that if you involve technical product matters. There's also attestation clause. Next one, we will see the meeting of the mind. The parties can form a contract only if they had a meeting of the minds. They must understand each other and intend to reach an agreement. So the knowledge of the products, the knowledge of an agreement, so they have to understand each other. A judge will make an objective assessment of any disagreements about whether a contract was made, whether or not reasonable person will conclude that there was an agreement based on the parties conducted. That is actually required submission document, fact, sometimes the expert to claim and give a testimonial about certain issue. The objective of theory of the contract can be seen in the case of Lucy versus Zimmer. That's all for today. Thank you very much and looking forward to see you in the next course. Thank you for having me.